Bueno, vamos pues a dar inicio a
Okay, so let's begin. We have here our first discussion panel. It's entitled Evidence, Errors, its Identification, and Strategies of Reduction. This topic is something quite new, at least for us here. And maybe we haven't paid enough attention to this topic when we are discovering some errors in judicial decisions. So whenever we find this error, of course, we have to put some remedy, but at the same time, we have to learn not to repeat the error, or at least not the same type of error. So this panel is going to tackle this topic. We have here 4 incredible experts here with us. They come both from Italy and from the Anglo-Saxon world.
Ustedes, como ya han visto, hemos intentado en este congreso que este congreso sea un congreso tecnológico.
As you have seen, we have tried the Congress to be quite technological here. We have our IT here, you have the application, you have all the bibliography, all the information about the speakers. So I'm not going to take more time to talk about their biographies because you can read it there. I will just say where they come from. Unfortunately, out of the 4 people who are in this panel, 2 of them are participating via Zoom. Some of us are so tired of Zoom, but it's quite a useful app. So those speakers, for health reasons, they couldn't come, but they have made the effort and they are here via Zoom. We are going to start with Professor Samuel Gross. He is accompanying us from the States, from the University of Michigan. Professor Gross was one of the first authors of this topic, and he was the founder of the Exoneration Registry in the United States. So if you're not familiar with this, I really advise you to go there and read it, because you will find so much interesting information about the errors and trials in errors and the different causes and how can we learn about this from these errors. So it's a real pleasure to have you here today. Mr. Gross, whenever you want, you have the floor.
Thank you, Carmen. It is a great pleasure to be here, except that I'm not here. And as you said, we've come to depend on Zoom over the past 2 years, and to love it and to hate it. And I am actually quite afraid of giving this presentation over Zoom, because I was so looking forward to being there and to seeing people and to having a real audience and to meeting colleagues whom I've heard about but never met. But I will do my best. Let me share my PowerPoint with you. With any luck, this will work without any problem. Okay. Okay, that appears to be working. As you mentioned, I'm affiliated with the National Registry of Exonerations in the United States. I'm the founder and now a senior editor of the National Registry of Exonerations. And what we do is collect and publish information on all exonerations in the United States since 1989 that we know of. That is to say, convictions of innocent people that were later discovered and the defendants were cleared and released. So far we have over 3,100 of them. We also have a less complete list of about 450 exonerations that occurred before 1989, and a growing section of our project that's on scandals based on systematic misconduct by government officials that led to thousands of improper convictions. We do 2 things. We tell stories. We tell the stories of these convictions and of the people who were sent to prison for crimes they didn't commit, and of the reasons that happened and how they were released, and are generating an archive of these stories that is extremely interesting and will be valuable in the future. And we count things. And although the stories are extremely interesting, probably more interesting than anything I'm going to say, I'm going to focus entirely on counting. I'm going to discuss these three issues with a few words at the end on how we might use what we have learned to reduce or prevent convictions of innocent people. The first question, does this ever happen? The answer, of course, is yes. There are well-known cases of innocent people who've been convicted going back hundreds of years, probably thousands of years. Nonetheless, in the United States, some judges and lawyers have felt impelled for years to deny this in some form. Here you have a statement by Judge Learned Hand, one of our most distinguished judges in the first half of the 20th century, updated 80 years later by the late Supreme Court Justice Antonin Scalia. These sound like authoritative statements, but they're not based on any evidence. These are articles of faith, like something that Americans like to frequently say, that we have the best criminal justice system in the world, for which there is no particular evidence. Americans also frequently say that we have the best medical care system in the world, for which there is negative evidence. So, first, who gets convicted for crimes they don't commit? Can't answer that comprehensively, but a couple of things show up. The first is, in the United States, black Americans, African Americans, are about 13% of the population, but as you see, they're a majority of all those who have been exonerated after being convicted of crimes they didn't commit. And they're a majority of the exonerations in most of the major crime categories that we identify: murder, sexual assault, rape, robbery, drug crimes. They're also overrepresented in all the other crime categories to some extent, even though they're not an absolute majority, except for white-collar crimes, which are primarily financial crimes, mostly fraud. I expect, in fact, there's indications that this is not a problem that's unique to the United States, that disadvantaged ethnic and other minorities in other countries are also more likely to be convicted of crimes they didn't commit. In Europe, that might be Algerians in France, or Roma people in various countries, or who knows who else. Second, what about the crimes that people are convicted of? If you just look at the exonerations we have, it could appear that the people who are most likely to be convicted of crimes they didn't commit are those who are convicted of the most serious crimes, especially murder, which makes up about 40% of the exonerations we know about, including a substantial number of death sentences, or rape and robbery, or drug crimes in particular. That would be misleading, because that fails to take into account the number of all the crimes in these categories. What you see in the right-hand column of this table is a set of estimates of the number of convictions for crimes for particular criminal categories in the United States over a 10-year period, somewhere around the year 2000. These are estimates because criminal justice statistics in the United States are terrible. We don't have simple numbers like the number of people who were convicted of murder in the country in the past year. We have approximations. And these approximations here may, in any particular category, be off by 20% or even 40%. As you'll see, though, it doesn't really make a difference for the point that I think we need to see. And that's what you see in the right-hand column here. Because the number of crimes is so extremely different, we can come up with general estimates of the relative likelihood of exoneration for people convicted of particular crimes. At the top, you see those convicted of murder who were sentenced to death. Those are the people who are far and away those who are most likely to be exonerated. And I've set their likelihood at 1. That's obviously an arbitrary number, but it gives us the ability to look at the relative rates for other types of convictions. And what you see here is that those who are convicted of murder but not sentenced to death in the United States are about 1/5 as likely to be exonerated as those who were sentenced to death. Those who are convicted of rape are 1/25, another reduction by a factor of 5 from murderers who are not sentenced to death. Those who are convicted of robbery down to 1 in 200, drug crimes 1 in 500. And at the bottom, when you get to misdemeanors, minor crimes, the rate at which people are exonerated is infinitesimal. It is tiny. There are perhaps 4 million or more such convictions in the United States every year, and perhaps 5 or 10 exonerations. It could be that, for example, defendants who are sentenced to death are more likely to be innocent than other defendants who are convicted of murder. But it seems extremely unlikely that that would be a difference by a factor of 5. It could be that defendants who are convicted of rape are more likely to be innocent than those who are convicted of robbery, although there's no particular reason to think that. But again, the difference in the rate of exonerations is huge. And there's an explanation for it that has nothing to do with the innocence of the defendants. In rape cases, DNA evidence is often able to determine with a high degree of certainty that an innocent person has been convicted, because the biological evidence that was left can be identified with a particular individual. That almost never applies in robbery cases. So robbers who are equally innocent, robbery defendants who are convicted and are equally innocent and convicted on equally bad evidence are because the magic bullet of DNA is not available to make a difference there. Where does this lead? If you ask then, how many false convictions are there? This set of ratios tells us, if we didn't already know, that the vast majority, perhaps 99 out of 100 or more, of false convictions that occur do not result in exoneration, never come to light, do not appear in our registry, and we don't know anything about them. That means that we can't, from that information in general, calculate anything like a rate for the frequency of false convictions. To do that, you need 2 things. You need to have a good estimate, if not an actual number, for the total convictions in the category you're interested, and you'd have to have a good estimate or an actual number for the total of people who are innocent, and we don't have anything like that. For that reason, criminologists have generally described the rate of false convictions of innocent defendants as a dark figure, a number that cannot be calculated. And I believe that's generally true, with one exception. We do have very good information in the United States about prosecutions of defendants who are sentenced to death, who were convicted of murder and sentenced to death since 1973. We know about each of their cases and what has happened to those defendants. And the rate of exonerations for them is so very high that it looks plausible that it might be a substantial proportion of all those innocent defendants who are convicted. That makes it possible to get at least an initial estimate of the rate of all convictions of innocent defendants who are sentenced to death. My colleague Barbara O'Brien, who is now the editor-in-chief of the National Registry, and I wrote a paper about this in 2008, and this is the central finding, and these are actual numbers. As of 2004, we knew of 86 exonerations among the 3,900 3,792 defendants who were sentenced to death in the United States from 2004 through from 1973 through 1989. That number, 2.3%, is an actual measure of the rate of exonerations for defendants sentenced to the United States to death in the United States in that period. It is necessarily an underestimate of the total rate of innocence for defendants sentenced to death in the United States, because it doesn't take into account those who are innocent but who have not been exonerated, or those who would be exonerated after the year 2004 when the database was closed. Several years later, Professor O'Brien and I, together with two excellent statisticians, published a more elaborate study that uses more detailed information about these cases to come up with a better, more complete estimate of the rate of innocence among defendants sentenced to death in the United States after 1973, and the number we came up with is 4.1%. This was published in the Proceedings of the National Academy of Science in 2014, and since then it has not been refuted, it has not been disputed. It is simply an accepted number, and it is, which we're quite proud of, because it is the one exception that we know of to the general difficulty or indeed impossibility of estimating the rate of false convictions. But this applies only to death sentences in the United States, and strictly speaking, only to death sentences from 1973 through 2004. It doesn't apply to other murder convictions or robberies or rapes. Nonetheless, with that estimate for death sentences, it seems plausible to say that at least 1 or 2% of defendants who are convicted of violent felonies in the United States are innocent. Beyond that, for other types of convictions, drug convictions in the United States, for example, or convictions for misdemeanors, lower-level crimes, we are back to basically guesswork. What about in Europe? We'll just say a few words about that. It appears that exonerations are much less common in Europe than they've been in the United States in the past few decades. There are few systematic data that I could find. The best appear to be from the Irish National Registry of Exonerations, which reports 19 exonerations in total, 12 of them since 1979, mostly murders and rapes. In other words, a pattern similar to the United States, and about 1/4 the rate for the population, although there are a few states in the United States that are like that, that have about that rate or lower. So, assuming this is true, and that the rate of exonerations in Europe is much lower than the United States, and certainly if it appears to be so, and if there are more, they've received much less attention, the question is why? And various reasons have been given. Perhaps the system of determination of guilt or innocence is more accurate. Perhaps the nature of the role of criminal defense attorneys in the United States gives them more power to take on cases like this, or the system of review of cases makes it easier to revisit cases 10 or 20 or 30 years later. All that may be true. I don't have any reason to doubt that those are possibilities. But I want to draw your attention to one thing that might make a significant difference. The National Registry of Exonerations includes 133 death sentences and 710 life sentences among the defendants who were exonerated. 170 of those life sentences are for crimes other than murder. And I suggest you also look at the average at the average sentences for defendants that were not sentenced to life, or in the case of some murderers, to death 33 years for murder, 23 years for rape, 17 years for child sex abuse. By the standards of most European countries, these are extreme sentences. And that may be a big driver of the high exoneration rate in the United States, because the cases that attract most attention, when people are most concerned about the possibility of innocent people being convicted, are those in which they were sentenced to all of the rest of their life in prison, or possibly in some cases sentenced to death. And there are many more of those in the United States per capita than in any European country that I know about. Why do we make these errors? And if possible, what can we do to reduce them? This is a chart of what is sometimes described the leading contributing factors that produce false convictions that later sometimes result in exonerations. The most common two are perjury or other false accusations by witnesses for the state, or misconduct by state officials, followed by eyewitness misidentifications, false or misleading evidence from forensic forensic experts, and false confessions. All of them, with one exception, are one variety or another of faulty evidence. The exception is official misconduct, which is a problem because it produces false evidence. It produces false evidence of guilt, and in many cases in the United States, it results in concealing evidence of innocence that might have prevented a false conviction. These are not, however, the leading causes of erroneous convictions. These are the causes for which we have systematic data. There are numerous causes, and many of them we don't know enough to say anything about. I'll give you one example. In Houston, in Texas, over a period of several years, over 150 defendants pled guilty to possession of illegal drugs and were convicted based on their guilty pleas. And then later they were exonerated because chemical tests that were conducted after they pled guilty showed that, in fact, they did not possess any illegal drugs. So why did they plead guilty? Which, by the way, happens a lot in the United States, defendants pleading guilty very quickly. What doesn't happen in drug cases, except in this one county in the United States over a period of several years, is that the drugs they supposedly possess are tested after guilty pleas. Usually that never happens. And as a result, we see that many of those people who pled guilty were innocent. Why? We don't know, of course, but the leading explanation, which is confirmed in some cases that we do know about, is pretrial detention. These were overwhelmingly defendants who were being held in jail pending trial and might have remained in jail for months before they would get to a trial. And they were offered an opportunity to plead guilty and get a sentence of days or weeks, or in many cases, a sentence that would enable them to go home immediately because they'd already spent days or weeks in jail. This is important. Anything like this, which creates an incentive for people to admit to guilt in order to get out of the system and go home, has a strong possibility of creating convictions of innocent people, especially at the lower end of the range of crimes. And I have no doubt that that happens in other countries as well. It could well be the biggest factor that contributes to wrongful convictions, but we don't have much information on it because the nature of the pretrial confinement in cases like this, if they ever come to anybody's attention, is often not something that appears in the record because it's not a factor that is likely to lead to a later exoneration. Finally, what can we do to reduce false convictions? It might help to look at some areas where there has been improvement. But I should say at the beginning that it's very hard to detect changes in the patterns of false convictions from the data we have in the National Registry of Exonerations, and particularly hard to detect improvements. I can explain that later if anybody's curious, but that means that only the strongest patterns are likely to show through. The most important and the clearest is the one you see at the top. The dates you see there are not the dates on which the defendants were exonerated. They're the dates on which they were convicted, typically anywhere from 5 to 35 or 40 years later. For defendants convicted before 2003, we have 256 cases of rape convictions in which the identity of the rapist was unknown. For defendants convicted from 2003 on, we only have 7 cases. In other words, those cases have almost disappeared. Why? Well, obviously because of the advent of pre-trial DNA investigation, which makes it possible to determine the innocence of defendants who are wrongly accused before they go to trial. This is a big effect. It's reduced the number of erroneous rape convictions by quite a bit, and it has reduced the proportion, the overrepresentation of African Americans among those who are exonerated to some extent, because they were heavily over-exonerated in this category of rape convictions. In murder exonerations over that same period, there's been a substantial decrease in the use of violence in interrogations of defendants, which has contributed to a decrease in the number of murder exonerations, the proportion of murder exonerations with false convictions. And there's been a decrease in the proportion of cases, the small but very important proportion of cases in which there was fraud by a forensic expert for the state. What can we do in the future? By way of background, let me say that it may be that the procedures for judicial evaluation of evidence make a great deal of difference and could be reformed in a way that would make the determination of guilt more accurate and prevent convictions of innocent people. There's no indication of that from the data we have. It's not likely to be a major factor among the cases we saw in the United States, but it certainly is an issue in some cases. What else could we do? Well, improvements in technology, for example, what happened when DNA became available, especially for rape cases, are the single best way to make determinations of guilt more accurate, if it's possible. It's not easy to do. The next thing that is probably most effective in the United States would be reducing misconduct by government officials. This is a big issue. A majority of all the exonerations that we see include misconduct by police officers or prosecutors, or both, creating false evidence or concealing accurate evidence that might suggest innocence. I do not mean to say that that happens frequently in all cases in the United States. That's not, our evidence do not show that. They show that it happens frequently among the cases in which innocent people are convicted. Reducing discrimination against racial and other disadvantaged minorities, also a big issue in the United States, would make another difference of significant size, at least in the United States. And finally, and most important, I think the difference that would, the change that would make the most difference would be an increase in the resources, the training, and the professionalism of police, of prosecutors, of judicial investigators, and of defense attorneys. That in itself might reduce misconduct by them, but also make their work more accurate and more informative for the judicial process. And, not incidentally, reforms of that sort all have the equally important advantage of making it more likely that the judicial process will accurately identify and convict those who are guilty. Thank you very much.
Muchas gracias al profesor Samuel Gross.
Thank you very much to Professor Samuel Gross. I think it's interesting to take from his presentation that it's so important to have empirical evidence of the wrong additional decisions, because this makes the difference. For instance, the system in the States is different than ours. They don't hide the errors, they make them public so we can learn from them. It's important to have this data. And as he was saying as well, this plea guilty. Now we have different systems of resolutions, and we have the short proceedings, and we can make errors systematically in this one. So we have to learn and compare from these experiences. Thank you so much to Professor Gross for his presentation. So now we have with us Professor Giulia Lasagni from the University of Bologna. She is a teacher of criminal procedural law in this university. Giulia, you have the floor.
Muchas gracias. Buenas tardes.
Thank you so much. Good afternoon, everyone. I would like to start thanking the organizers of this Congress, this event. It's a great pleasure for me to be here today. Unfortunately, my Spanish is not that good, so I will going to speak in English.
And so what I'm going to talk about, briefly promise, going a bit more into detail on one specific kind of evidence and error and miscarriages of justice, is the specific topic of how false confessions are relevant when we talk about miscarriages of justice. False confessions are not perhaps often, as we have seen also before, the most relevant in terms of percentages, but they do present a few peculiar issues which are very interesting from a procedural point of view, and especially when it comes to the evidential legal reasoning and how could or should our systems be changed and amended in order to reduce the risk factors. So what I'm going to do briefly is to pass through just a few elements that characterize miscarriages of justice, then to focus more on false confessions, to analyze a bit how they differ, because that's a very complex and variegated topic that sometimes is not so, of which sometimes legal operators, and that's a problem, not just the public, but also legal operators are not so aware of, and then to finish with some implications for evidential legal reasoning that hopefully will be also helpful for further discussion and suggestion. Okay. So miscarriages of justice, of course, it's an enormous issue, and what I would like just to highlight is that it is a complex issue. In that sense, it means there's very different ways in which miscarriages can be performed. There's very different causes, and one interesting common element that I think would be relevant also, and I will say at the end why in terms of approach that we apply to this matter, is that they're strictly related in one way or another also to the use and the interpretation of forensic evidence, either because forensic evidence is related in the commission of the mistake, let's say the case of the fraud expert laboratory, or because they're useful to remedy to the miscarriages of justice. DNA exoneration, of course, it's the most famous example. But one other very crucial issue that I think it is really pivotal in case of false confession is that most miscarriages of justice do not occur intentionally, or at least they do not start as intentional mistakes. Sometimes it happens, but in many cases it is a slow process of building up mistakes over mistakes, arriving to a point in which it's more difficult to admit it has been a mistake than to actually try to correct it. And therefore there is this mixture of ignorance, prejudice, injuries, and negligence, which are all foreseeable causes. And therefore, it is something that cannot just be left to let's try to be better, but that requires some scientific and systematic approach and reform, I would say, in order to be dealt with. And in this sense, I think there is a need for a multi-layered approach that goes through the understanding and identification of the causes of this phenomenon, but also to rethinking the role and the magnitude of evidential legal reasoning and how this should be shaped or could be shaped differently in case of certain kind of mistakes. Here I'm talking just about false confessions. And above all, to, I would say, finally embrace a multidisciplinary approach. When we talk about other types of miscarriages of justice, often there is reference to biology, genetics, think about DNA examination or ballistics. But also when we talk about false confessions, there is a strong multidisciplinary approach that sometimes, especially coming from the Italian legal background, does not belong yet to the normal training of the judiciary, of legal operators, of lawyers, prosecutors. That is a multidisciplinary approach that encompasses also forensic psychologists. And this is a multidisciplinary approach that is pivotal to understand the magnitude of the phenomenon of false confession and how we could deal with that. So why are false confessions so interesting? Well, on one side, because they are kind of a cinematic phenomenon. Everybody kind of can picture what a false confession can be. But still, when we look at that within a proceeding, they are also quite complicated sometimes to identify. They are different. There's different causes. There's different ways of manifestation. I'm going to tackle the topic very briefly in a moment. And this complexity is often ignored by the legal operators. Not often intentionally, sometimes you rely on the maximum on expertise that you have learned from your colleagues, and that's how you approach also to this matter. And this is dangerous, I would argue, because first of all, it gives for granted an assumption, which, however, does not have very much scientific foundation, to my knowledge at least, that is, that we can distinguish when a person is telling us the truth or not. And therefore, that we can assume that if a person confesses something, most likely, and we don't think about the case, the most gross cases, I don't know, torture, most likely he did or she did so because of that declaration being mirroring reality. And this is actually quite not the case in many situations. Then, similar to other cases of miscarriages of justice, false confessions are particularly dangerous because they tend to flatten the weight of other piece of evidence. Meaning, if there is much focus in the investigation on obtaining a false confession, then the relevance of looking elsewhere, or finding other investigative paths that might be also the true reconstruction of facts becomes less interesting if there is so much focus on obtaining that statement from the defendant. And that brings us to a kind of a catch-22 situations in which, on one side, looking so much to obtain a confession reduces the magnitude of potential reconstruction of facts, and therefore police or prosecutors get more focused just to find a confirmation of the initial potential way of reconstructing the events. And on the other side, after there has been a confession, this could also be the cause of a tunnel vision, let's say, effect and confirmation bias. As I was saying, there's very different ways in which false confessions can occur, as classified by forensic psychiatrists. We can distinguish between false voluntary confession, coerced compliant confession, false coerced internalized confessions, and those are all different types of confessions, scientifically studied, that are caused by different reasons that appear differently during the proceeding, and also sometimes in different phases of the investigation, that pose different risks. And therefore the question that I will try to answer or provide some insights at the end is, do we need to treat them differently in case, from a perspective of evaluation of evidence? Do they require different reasoning, given that they are so different in itself? to have a reconstruction, let's say, or what could be this difference. Voluntary false confession. Voluntary false confessions are those false confessions that are either deriving from a person that declares himself or herself guilty when that is not true on purpose, because without any pressure from external sources, let's say, because of the need of protecting someone, or because of the need to build an alibi, for instance, for someone, or because of some, and here I beg your pardon for my rough terminology, of some pathological issue, a person that has an uncontrollable desire for notoriety, a kind of need to expiate something. And that is, there are many cases in that sense. And in this situation, an important role that should not be underestimated is played by media. Often, especially in the case of pathological false confession, people need to get the detail because they didn't commit the fact. So when they confess and provide some information, they need to get those information somewhere. And often this information comes from the media. So a good way for police or prosecutors to understand whether the person is falsely confessing or not could be also to be very aware of what they disseminate to the media, to the public opinion, and then to cross-check whether the information the person is referring are only or mostly just those that are also present in the public media. And this type of false confession has a peculiar feature, that is, it finds its origins outside the proceeding. And that makes, I would say, easier to identify it, and to a certain extent also to remedy to this mistake since the beginning and avoid that it becomes a real miscarriages of justice with, for instance, a false conviction. However, that does not mean that it is harmless. There are cases, here I just put one that is famous from the Italian perspective, of this person that was killing children, in which there had been a false confession, a voluntary false confession, pathological one, and while police got to spend a lot of time interviewing this person, believing this person was the real culprit, in the meantime the killing went on, and therefore the amount of time and resources that were lost in false confession had a concrete impact in terms of the harm that was caused in the specific case. Much more complicated instead is the false coerced compliant confession, because in this case the person is pushed to confess because of a pressure that is exercised by the often police during interrogations, prosecutors, but most often police. And what is relevant to highlight here is that often it is believed that only very vulnerable people, or only if a person is subject to torture or alike behaviors, can be forced to, in the end, provide a false confession. And this is actually not the case. Forensic psychology has analyzed and has verified how the target of people that usually releases such false coerced compliant confession are subjects with psychological vulnerability, but also, and more often, young people, confused people, tired, suggestible, submissive, or people with compliant tendencies, which I don't know, but could encompass a good amount of people that I know, me included, and perhaps also of yourself. So it is not something that doesn't concern the average person. That's what I mean. And also, it has been demonstrated by those studies how it is relevant. It's not the only cause, but it is the main cause, the way in which interrogation is carried out by the police. And here again, there's another myth to be destroyed. It's not just about what would be in the Council of Europe violation of Article 3 of the Convention on Human Rights, torture, inhuman and degraded treatment. Of course, that could be a cause of a false coerced compliant confession, but also more often it is just about the application of certain techniques, which we might be more accustomed to also, I don't know, from movies, the good cop, bad cop technique, minimizing consequences of the confession, simulating non-existing evidential rule, the contamination effect. So it is a whole amount of more subtle technique that do not amount to violent behavior in what we are most likely to think about, that are directly causing also this kind of confession. And of course, also here applies what has been already illustrated before. There are also other causes that could contribute in putting pressure on the defendant and force him or her to falsely confess, like the distorted use of pretrial detention here as well, the fact of being able to activate out of trial procedures without judiciary control, for instance, in cases where there is very much the discretion of the prosecutor. But also, and I would say this is more a cultural problem, seeing a confession one way or another, or especially for certain types of crimes, as a way to close the case. That's the kind of evidence you need to close the case, and therefore there's much effort put by the investigators in obtaining a confession as a way to close the case, which, if you think about it, it's something that perhaps today does not find, if ever it had before, but today it really doesn't find much ground any longer. It's much more secure to a certain extent to find evidence concerning, I don't know, metadata or other kind of digital traces rather than forcing the people to admit his or her guilty. And this is more tricky because this kind of false confession finds its causes within the criminal justice system, either in the police way of carrying out an interrogation or in the way the procedure is structured. And this, I will say that in a moment, makes it more difficult to identify the phenomenon and to put a remedy to it, and to put a remedy to it before it is too late to create a miscarriages of justice. And then, before going to that, last briefly about the forced coerced internalized confession, the third type of false confession that has been schematized. This takes elements from both voluntary confession and false coerced and coerced confession, in the sense that those are cases in which the person admits something that he or she did not commit, and does so because of some pressure. For instance, the pressure during an interrogation, it is quite a compelling atmosphere being interrogated by the police. And for a moment, or a bit of time, let's say, this person gets to believe that he or she actually committed the trial. So there is, again, this kind of vulnerability. And in this sense, the police again places, or who carries out the interrogation, places an important role to the extent that, of course, this person not having committed the crime needs to get elements in order to confess what he or she did not commit. And therefore, often these kind of confessions are generated when police start to provide some kind of explanation. For instance, you don't remember about it because you got amnesia. You know, it's quite common to get amnesia. Or you were drunk, that's normal not to remember anything after that, and therefore that's why you committed the crime, although you don't remember it. And if this person, for the context and the general surrounding, gets to believe that, often can release a confession which is recanted after a period of time, usually a short period of time, but that often is too late to avoid a miscarriage of justice. Why is it too late? And coming also to the more towards the end, it is too late because often a confession is used to bring the investigation to an early closure. You get a confession, there's no need to go further. There's no need to find corroborating elements, not necessarily. There's no need to look for other possible alternative explanations. And therefore, basically, the investigation is closed. And that is the first type of mistake. Of course, that does not mean that there will be a false confession in the end. For instance, looking at the very poor, because as was said before, in Europe especially, we have a problem about data in this regard. Looking at the poor data we have in Italy, for instance, we can see that there is a certain amount of false confessions, but the rate of false convictions, at least according to the available data, is not corresponding. So there is much more this possibility of false confession happening that can, however, be filtered and selected and barred from bringing to other results later on. But that's a different issue that concerns more legal, evidential legal reasoning, and I'll come to that in a moment. However, there are also measures talking about potential mitigating strategies, how to reduce mistakes and factual errors. There are already in this phase some measures that could be taken that could help in reducing the risk of false confessions from happening. Of course, that's different from type of false confession to type of false confession. But for instance, the recommendation of video recording interviews, which is often recommended by the literature but not so often then applied in practice, could be a way to reduce this risk. Of course, it is just a way, because then depends what is recorded by the camera. If you record only me, you don't see what is happening just close by. So, of course, that's not a perfect solution, but can help in reducing the risk of false confessions from happening. And the same to strengthen the presence of defense counsel. And by presence, I mean an active presence of defense counsel. That is not just physically present, but that he is entitled and empowered by the system to stop the investigators, to ask questions, to ask for a moment to talk with his or her client. And therefore, this also requires really a training and a culture of the defendant, who has to see his or her role as something separated to a certain extent from the other roles of the judiciary. One of the causes that forensic psychologists have found in helping the perpetration of false confession is that sometimes lawyers are more afraid to put themselves in contrast with the prosecutors they have to deal every day, the judges they have to deal every day, than rather to perform, let's say, their task till the end. So that's a set of first measures that could be applied to reduce the risk of this kind of false confessions from happening. But however, the possibility that this has then to become a false conviction depends highly on how this piece of evidence is assessed during the trial. And this brings us back to the opening question. Do we need specific rules for confession? First question, do we need specific rules for the different types of confession? I would argue it is difficult. It would be perhaps better, but it is difficult to distinguish between different types of confessions, because usually you're able to see this real origin and classification exposed. So it's very difficult to know from the beginning which kind of false confession this is going to be, or at least to know from an external perspective. That said, however, on the first issue, that is, do we need specific evidentiary rules or an approach towards confessions as such in order to prevent false confessions to become the ground for false convictions? I would say that our systems, I'm talking mostly about European systems, but not just, perhaps do need substantial recalibration in this sense. The idea of relying on an overall approach on the judicial discretion in assessing whether a confession is reliable or not, whether it has been released voluntarily or not, does not really prove satisfying in terms of preventing this confession from generating a false conviction. It doesn't mean it cannot happen, but often there are structural features that make it difficult from happening. And in this sense, if you want, there is a big role played by structural negligence. If police or prosecutors are not trained on how to use certain techniques rather than others, because scientifically it has been proven that using certain techniques is more likely to cause a false confession rather than other techniques. Famous, for instance, the case of the RAG techniques in the US versus, let's say, the peace techniques in the UK, which have been developed after a series of miscarriages of justice on purpose with the goal of preventing these cases to occur again. So first there's this issue that is, however, mostly internal or partial internal to the criminal justice system. And then there is a certain, if you want, deviated esprit de corps of how understanding, transparency, and the role of all the legal actors is often perceived. And I would say I couldn't find a better example of that than the statements released by Justice Denning in 1980 in the infamous British case concerning Miscarriages of Justice, about the Birmingham 6 case, in which the judge that had to assess whether to give a remedy to the persons, the convicted that were asking for a reopening of the case, was saying explicitly that doing so would have meant to admit that the police were guilty of perjury, that the confessions were improperly admitted, that convictions was erroneous, and doing so would put in such a bad light the judicial system that it's rather better not to proceed in this sense. Now, this is quite extreme, but this idea that it's better to preserve what has been done in the past rather than challenge the results of, in the end, that's also the case now with your colleague, because you have to say that someone before with whom you as a judge or as a prosecutor, a police officer work with made a mistake, which is human, but still, it is something that it's also humanly difficult, but I would say absolutely necessary in order to break this chain of potential mistakes that in the end could lead to a false conviction. So, to conclude, what could we do to try to reduce this risk also from an evidential legal reasoning point of view? Why I was saying before that leaving the power to assess the issue mostly or just to judicial discretion did not end up being a great solution in this specific case. Well, because, for instance, a good example, I would say, is the case of recantation. Often, confessions made before the police are recanted during the trial, but still there is often highly scientifically ungrounded belief that the first statements is more reliable than what comes afterwards. And therefore there is a kind of, if you want, psychological difficulty in trying to also consider the context in which these statements had been released, and in practice to say, I shouldn't consider the first statements as true, and I rather believe on the recantation later on. So again, since the problem is complex, also the answer, I believe, it is, let's say, a structured one that passes through increasing training. Also, as it is true for miscarriages of justice in general, it is also true in the specific case of false confession, training of legal operators, training of judges, prosecutors, police officers, and also lawyers, however, being aware of these conditions. Getting data, we do need data. For instance, it is very difficult already in Italy and many other European states to get specific data on miscarriages of justice as such, and to get a specific data on what was the origin of the miscarriage of justice, it's even more difficult. So we do need data to understand the magnitude of the phenomenon, but we also do need a, I would say, different approach to the evidence. In the case of confession, I would say it is necessary on one side to finally put into place those procedural safeguards that often remain only at the level of recommendations, for instance, video recording of interviews, for instance, ensuring that the lawyer is present, especially in the first interactions with the police, but also it could be worth thinking about specific admissibility rules, for instance, the need for corroboration elements in case a confession is to be used as a ground element for conviction. And that, of course, applies all the times, and that is in order to prevent a potential false confession to become the sole or the main element upon which a conviction is wrongly issued. So I thank you very much for your attention. I hope I was in the time, and again, muchas gracias.
Muchas gracias. Muchas gracias, Giulia, por.
Thank you very much, Giulia.
Muchas gracias, Giulia, por tan interesante.
Thank you for such an interesting presentation.
Charla. Evidentemente estamos aquí para tener un
We are
acercamiento
here today to have a different approach towards evidence in general. Confession is clear, as she has just proved right now, is one of these evidence, this proof that requires our attention. We cannot just close cases because there is a confession, because behind this confession there can be a lot of misconduct, and then at the end of the day we take erroneous decisions. It's very important to talk also about the training of police forces, because we are training judges, lawyers, but what happens with police forces, because they are the first ones that are in the case. They are in many cases our sources and the source of this error, because they are the first to arrive. So we have to pay a lot of attention to this. We have now with us our third speaker, Professor Daniel Epps from the University of Washington in San Luis.
Professor,
please, you have the floor.
Thank you so much for that introduction, and thank you to the organizers for inviting me. I've never been to a conference like this that brings together so many people from so many parts of the world, and I've already learned a great deal just in the last hour, and I expect to learn more over the course of the week. So the topic of the panel is factual errors in evidential legal reasoning, identification, and strategies of reduction. And so I'm going to try to follow that topic, and I'm going to talk about three things. The first is factual error. The second is legal reasoning. And then finally, I will try to connect those two ideas in talking about identifying and reducing factual errors. I'm an American professor who teaches criminal law and criminal procedure, and for that reason, my remarks are going to focus on errors in the criminal context, and my discussion and examples will draw on American law, but my hope is that some of my observations will provide insights that go beyond criminal law and beyond the American context. And I was excited to be on this panel because error has been a significant topic of my work in criminal law and procedure. I've written about both factual errors and legal errors. And what's the difference? In the criminal context, I understand, and I think that the definition we've been working with today is a factual error is the conviction of an actually innocent defendant, or also the acquittal of an actually guilty defendant. A legal error, by contrast, is the failure to follow some kind of binding legal rule during the criminal process in either the investigative stage or the adjudicative stage. There's a relationship between these types of errors, between factual errors and legal errors, but it is an imperfect relationship. Some factual errors may be the result of legal errors because certain procedures weren't followed that made the factual error, perhaps a false conviction, more likely. But not all. Some innocent defendants may be convicted despite there being no legal error to which you can point to at their trial. It could be that the jury just made the wrong determination, or the evidence happened to point in a particular direction, and then later we determined that that was erroneous. And some serious legal errors may produce factual errors, but some may not. And so why is there this mismatch between what I'm calling legal errors and factual errors? It's because legal rules do not always exist to prevent factual errors, but may protect other values. And when I talk about legal errors in the American context, many involve the federal Constitution, which is the source of the most important rules governing the criminal process in American law. And a number of the rules coming from the Constitution do not directly promote the goal of factual accuracy. So one example of a rule that we have that does not promote that goal is the Fourth Amendment exclusionary rule. This is a rule under which if evidence is obtained as a result of illegal police practices, so valid, probative, relevant evidence, but it's obtained through a search without a warrant or something similar, that cannot be admitted at the criminal trial, subject to a lot of complicated exceptions that I won't talk about here. And there you have a situation where there is, probative evidence that is being excluded from the finder of fact in order to promote other values. The value of deterring certain kinds of police misconduct in the search phase. And other rules may aim to protect innocence, but may do so in an imperfect way. Another example from our Constitution is the Sixth Amendment Confrontation Clause. It gives defendants the right to confront their accusers in criminal cases face to face. So it means that certain kinds of statements that were made out of court cannot be admitted at the criminal trial unless the person who made the statement is there and available for cross-examination by the defendant in the criminal trial. Sometimes this is going to prevent the introduction of unreliable evidence that might contribute to a factual error, but other times it's going to result in the exclusion of relevant and probative evidence, and then could actually make factual error more likely, even if we correct the legal error. So I've laid the groundwork, and from here I'm going to develop three claims. One is about factual error, one is about legal reasoning, and then one about the connection between those two concepts. My first claim is that one of the conventional ways that the American legal system, and I believe some other systems, think about factual errors, and in particular the distribution of factual errors between false convictions and false acquittals, is misguided and counterproductive. My second claim will be that in a legal system, there can be a serious tension between redressing and preventing legal error and the prevention of factual errors. And then finally, I will turn to the panel's ultimate topic and argue for how, in light of those first two claims, a procedural system might better orient legal rules toward the goal of preventing and reducing factual errors. So let's start with factual error. This is a concept that we've already been talking about on this panel. But to reiterate, what does this mean in the context of the criminal legal system? It means an outcome that is inconsistent with the actual facts. A defendant who did not commit a crime being convicted of a crime, or a defendant who did in fact commit the crime being acquitted of the crime. And I think most people, and presumably many people in this audience, would believe that these kinds of errors are unfortunate. We would prefer that they not happen, but we also recognize that no procedural system is perfect, that errors will occur. And in the American system, in terms of the way we conceptualize the system at the level of theory. I don't think this is true as a level of in terms of actual practice, but we'll come back to that in a moment. But in the area of lofty high theory, we say this. We say, we'll accept that errors will happen, but we're going to seek a certain distribution of errors. We think it is far worse to convict an innocent person than to acquit a guilty person, that the costs of these kinds of errors are different. And this way of thinking has a long lineage in American law as a justifying ideal for the system. I think in light of the exoneration revolution in the United States, it has become clear that we're not honoring this in practice. Nonetheless, it does a lot of work in how actors, both inside and outside the criminal justice system in America, think about the system. So we have this famous saying that comes from the 18th century jurist Sir William Blackstone. I imagine it's familiar to a number of you, that it is better that 10 guilty persons escape than that one innocent suffer. Blackstone was drawing on earlier thinkers like Hale and Fortescue, but this idea goes much further back before the Anglo-American legal system. It can be traced back to Roman law, to Aristotle, and to the Old Testament. And this way of thinking, I think, is deeply ingrained in many legal systems. And so in American law, it's deeply intertwined with the idea of reasonable doubt. A defendant may not be convicted unless the state can prove his guilt beyond a reasonable doubt. And it serves to justify other procedural rules that make it harder for the state to convict defendants. And I think many people would endorse this idea wholeheartedly. It has an intuitive appeal. As a side note, it's not actually clear how many people, at least in America, actually believe it. When you poll regular people, some of them say they don't believe it, but it nonetheless is a theory that people, it's a thing that people say all the time. And despite how much it's repeated, I think it's the wrong way to think about error in the criminal justice system, although that claim is going to be not quite as controversial as it might sound. My claim is that we shouldn't be thinking about procedural rules in terms of how they distribute errors. We should instead focus on the degree to which they produce reliable outcomes. So why should we get away from this idea of the distribution of errors? So first, it's a fallacy to think that procedural rules will necessarily produce any particular distribution of errors between false positives and false negatives, false convictions and false acquittals. There's a naive assumption that the high threshold for the burden of proof will produce a certain mix of errors. A 90% threshold for certainty is often said to reflect the view that false convictions are 9 times worse than false acquittals. But this is wrong. The standard of proof by itself tells us nothing about how the system will distribute errors. Instead, we would need additional pieces of information. We would need information about the accuracy with which juries assess guilt, and also the percentage of innocent defendants who are among the pool of defendants being charged. But we do not have access to that information. It could be the case that there are many such defendants, innocent defendants being charged. It could be the case that there are few, and it could be the case that juries do a good job or a terrible job of sorting between them. But I think this focus on the distribution of errors is wrong for additional reasons, because it reflects an assumption that there is a significant trade-off between the two types of factual errors in criminal cases. That to reduce false convictions, we necessarily need to increase false acquittals by some significant amount, and ostensibly vice versa. This is a zero-sum game. There's going to be winners and losers when we're trying to figure out how to reduce error. And the implication of this is that we cannot seek to sort of eliminate or prevent errors generally. We can just choose where they are distributed. I think this way of thinking also creates significant tension between the goal of reducing error and the desire for crime control. That this idea that we to eliminate or to reduce false convictions, it's going to really jeopardize the system's ability to engage in crime control, because it will let many guilty people off the hook and put them back on the street to commit additional crimes. But this is not at all clear. Some procedural protections could increase or decrease one type of error without producing any cost or benefit for error reduction in the other direction. And some procedural rules might just decrease certain types of errors without producing any errors in the other direction. So these things can be, the idea of reducing error can be made consistent with the societal demand for crime control, at least in some contexts. And a final problem is that this focus on the distribution of errors has, I think, a distorting effect. If people believe that our system is really designed to prevent false convictions and at the cost of letting many guilty people go free, it makes us more comfortable with imposing serious punishment on the convicted, even though some of those people will, in fact, be innocent. Because no system can really reduce either type of error completely. Nonetheless, in our system, because we buy into this myth that we let so many guilty people free just to avoid those false convictions, we have this great degree of confidence in convictions. Supreme Court Justice Sandra Day O'Connor wrote once that our society has a high degree of confidence in its criminal trials, in no small part because the Constitution offers unparalleled protections against convicting the innocent. And as I think we saw with Professor Gross's presentation, in reality it does not look like those unparalleled protections for protecting the innocent are doing as good of a job as we might think they are, or certainly that we would want them to be doing. Okay, for these reasons, I contend we should not try to emphasize the distribution of error and try not to see different types of error as trading off against each other. Instead, we should try to identify strategies to minimize both false positives and false negatives, because some strategies might simply reduce errors across the board, although others may not, and more on that in a minute. I'll now turn to legal reasoning. And I think legal reasoning is critical to reducing errors, and that rules are important. We should not permit criminal trials to just become free-for-alls. But at the same time, I think certain types of legal reasoning can conflict with the goal of reducing factual errors. And I'm going to discuss two ways in which this occurs in the American legal system. And this is where I'll discuss the other type of error, legal error. And in the American system, we're very, very focused on addressing legal errors. We have a complex body of constitutional rules that govern almost every aspect of the criminal process, from investigation through adjudication. But those rules are almost entirely about procedures. Did police follow the rules when searching for evidence? Was the trial conducted in accordance with procedural rules? And these rules do not actually create much room for courts to ask directly whether there was factual error in any particular case. So one feature of our system that often astonishes people, even in America and elsewhere, is that in post-conviction review, there is no right to overturn a conviction on the basis of actual innocence. The Supreme Court has never recognized such a right. It has never even recognized a right against the execution of a prisoner who is actually innocent. Instead, actual innocence is only relevant insofar as it enables a defendant to raise a claim of procedural error that otherwise it would be too late to raise. So actual innocence matters only indirectly. There's no freestanding right to obtain release if one can establish actual innocence. And courts have also been reluctant to recognize other rights that would protect against factual errors. There's no remedy if the government negligently loses evidence that the defendant could have had tested to prove his innocence. That came from a case called Arizona versus Youngblood, where the police had just lost some evidence that could have been tested for DNA, and the Supreme Court said no remedy. And then many years later, that defendant, Larry Youngblood, was able to have a different piece of evidence that had not been lost tested for DNA, and he was actually exonerated and released from prison. There's also no constitutional right to obtain access to evidence for DNA testing that could establish innocence, even when it is in the government's possession. So why are American courts unwilling to recognize rights that are directly aimed at addressing factual error? There are many reasons, but I would argue that one is that our system is so focused on enforcing procedural rules. I don't mean to say that procedural rules are unimportant or that they don't require enforcement, but too great an emphasis on procedure alone could come at a cost, because it could eliminate the space and willingness for the system to provide remedies to address the substantive failures that we've talked about today. And part of that reason is because actors in our system believe that our elaborate procedural rules produce good outcomes. When the procedural rules have been followed, the outcomes are necessarily fair and need not be questioned. And this relates back to the phenomenon I talked about earlier, because everyone believes our system provides such protections for the innocent. Actors within the system feel very comfortable that convicted people are guilty and deserving of the punishment that they will receive. So consider another example from the U.S. Supreme Court in a case called Callens versus Collins. The conservative justice Antonin Scalia defended the constitutionality of the death penalty. And he used a case, a different case, as an example. The case involved the brutal rape and murder of a child, and he used that example to show defendants who would clearly deserve the death penalty. After describing the facts, he said, how enviable a quiet death by lethal injection compared with that, with the crime. And yet years later, the two defendants that he alluded to were exonerated by DNA evidence in prison. And a system with less confidence in our procedures might be more willing to accept the possibility of errors and more able to correct those errors. A related problem in legal reasoning in our system is a very strong focus on the separation of functions. Each actor within the system is designed to perform only their designated function. Judges are supposed to interpret the law, prosecutors are supposed to determine if charges should be brought, and juries must make the ultimate factual determination of guilt. And judges sees these rules as rooted in the basic separation of powers laid out in the Constitution. And for this reason, our system is very hesitant to permit one institution to second-guess the work of another. Judges don't like to question prosecutors' charging decisions. Juries are not supposed to interpret the law. But particularly important, judges do not like second-guessing jury verdicts on the basis that the jury got it wrong. That means that jury verdicts are usually the last word. Courts are very, very hesitant to overturn them. Now, our constitutional protection against double jeopardy means that judges may not overturn a jury acquittal, even if it appears clearly erroneous, and then judges are also unwilling to overturn jury convictions simply because they believe the jury made the wrong decision on the basis of the evidence. The standard for a judge to overturn a conviction on the basis of the evidence, the sufficiency of the evidence, is quite demanding. A court is only supposed to overturn a jury verdict based on sufficiency of the evidence if viewing the evidence in the light most favorable to the prosecution. Under that vantage point, the light most favorable to the prosecution, no rational finder of fact would have convicted. So it requires saying that the jury was not merely wrong, but in fact irrational. And few such challenges succeed. And the American legal system's obsession with the separation of powers is similar to its focus on procedural protections. Both are legal commitments to process. They're both formalist commitments. They represent the notion that the most important thing is to follow certain rules and not necessarily to ask whether those rules produce good outcomes. Now, those rules are, at some high level, supposed to produce good substantive outcomes, but in practice, those commitments may be in tension with our goal of producing good outcomes insofar as the most important thing we might care about is the prevention of factual errors. Rules are necessary to ensure that the process is fair and consistent, but an obsession with legal rules governing process can be dangerous because it forgets that process for process's sake is not the fundamental goal of an adjudicative system. And a system that is obsessed with the fairness of process may lack the tools to correct errors that are not the result of a flawed process. So I've discussed factual error and legal reasoning, and so I now want to build on my observations to discuss strategies for the identification and reduction of error. And what would a system better committed to this goal than the American system is look like? And here, I'm unfortunately not going to offer much in the way of specifics, but I think some of my co-panelists and many of the people in the audience will have better ideas than I will about some of the specific strategies. But just at a higher level, I think we should reject strategies that think of error reduction as a zero-sum game. We should not believe that we can't reduce false convictions while also increasing false acquittals, and vice versa. Instead, we should just try to identify solutions that will reduce the overall rate of error. And there could be ways in which we can change our system that reduce one type of error without having any meaningful costs in terms of increasing other types of error. Is this possible? I believe so, though it is challenging to identify precisely how to do it. And part of that challenge is we don't know when the system errs. We don't know when errors actually happen, so figuring out how to design rules to prevent errors is a very, very challenging exercise, because we have no way to observe the correct outcome. And if we did, we would just not create the errors in the first place. But we do get some insights. The DNA revolution and the exoneration revolution in the United States that Professor Gross talked about have taught us some things about where we might be making errors and how to prevent them. And the legal scholar Brandon Garrett has studied many of the cases involving exonerations and has drawn conclusions from them. He analyzed the legal processes that led to the exonerated individual's initial convictions. And these findings illustrate some of the problems I note. And so before DNA exonerated these defendants, most of the defendants actually challenged their convictions on the basis of procedural violations. Few asserted freestanding claims to obtain release based on actual innocence. Some number of them had their initial convictions reversed before being again convicted, but those reversals were typically based on procedural problems. And the percentage whose convictions were reversed for procedural reasons was not dissimilar to the percentage of non-exonerated defendants who were never exonerated. So basically, our system of procedural error correction does not seem to be sorting that well between substantive outcomes in terms of factual errors, factually guilty and factually innocent defendants. But there are other lessons that are more promising. A number of defendants were convicted on the basis of later debunked forensic evidence. We've seen various types of supposedly reliable forensic evidence revealed to be highly unreliable. But our legal system has done a poor job of restricting such evidence, and better gatekeeping around forensic evidence could reduce false convictions without having any appreciable effect on increasing false acquittals. And indeed, those kinds of things and increasing access to DNA evidence, for example, is actually very consistent with the goal of crime control, because it could prevent the factual error of the conviction of an innocent person, but also help us identify the actual guilty party who might otherwise be free to commit other crimes. the system might also need to spend less of its energy enforcing procedure so that it could better focus on producing good substantive outcomes. I don't mean that to suggest we should abandon our commitment to fair procedures, but it might suggest that we look for ways to promote procedural fairness that do not require the regular reversal of convictions, that we try to spare the remedy of reversal for cases where we think we're preventing a miscarriage of justice, preventing a factual error. I argue that we should prefer those reversals, and I think we assume that the system will only tolerate a certain number of reversals. We should prefer them to be used on the defendants who least deserve punishment because they are actually innocent. And there could be better ways to police procedural error by trying to prevent procedural violations before they occur. A system of fast-paced appeals could permit trial courts to correct errors before a jury verdict, and all that said, if we have to choose between protecting process for its own sake or the goal of avoiding errors, we should prefer to minimize errors. Ceasing to fetishize procedure for its own sake would also enable us to better recognize the possibility of error. A system with great confidence in its procedures, as I've said, gives us actors too much confidence that the procedural system is creating just outcomes. And I think a sense of humility will better equip us to recognize, correct, and ultimately prevent errors. Now, these changes would require a fundamental reorientation of criminal procedures in American law. Some of them might be very difficult, given the particular criminal procedure rights that are enshrined in our Constitution, but not all changes in the directions I propose would be impossible, and other legal systems may be better positioned to address errors in the way that I propose. Even where changing rules is not possible, we can at least change the way we think about and understand error. And in criminal procedure, eliminating factual error should take priority over eliminating legal error for its own sake, and we should stop thinking about factual errors as in competition with each other. And we must remember that the law should be subservient to the substantive outcomes we want law to produce.
Thank you very much, Professor Epps. Muy interesante.
That was extremely interesting, your presentation, just like the other two that we heard before. It is important to underline how interesting the rules of the evidential institution govern it. Sometimes they do not help us avoid errors, but rather lead us into them. It has also been mentioned that there's an interest in expert witness evidence and how these expert expert words that are tend to be considered reliable in practice, even if they may contain mistakes, and can help us produce this kind of miscarriages of justice. Now, one of the key points that we cannot just neglect from this extremely interesting presentation was the fact that there was a distinction between two types of errors. We should not just think about false convictions, but also on false exonerations, and how these two pieces of data interact with one another. So one of the questions that we may ask is, how can we reduce errors at large, not only false convictions? Thank you very much, Professor Epps, for such an interesting presentation. We will move to our last speaker, Professor Luca Lubaria from the University of Rome 3, who will be joining us on Zoom. The floor is yours.
Gracias. Un gran pesar no estar allí con ustedes. Esta mañana con la fiebre.
It is a pity that I couldn't be here with you. I couldn't fly this morning and get to see wonderful Girona. I'm extremely sorry about this, and I hope that I don't take too long for you. However, it is a pleasure and an honor for me to be here online in this first day of such an extraordinary event. The Michele Tarufo Evidence Week is a unique event and a brilliant idea. So I think that we should all be grateful to Jordi Ferrer and his team. I'm impressed about everything they have achieved. As it has been said, I was asked to speak in Spanish during this panel discussion, where mostly English is spoken. And we do this also paying tribute to Michele Tarufo as a homage to a cultural universe, that of Spain and Latin America, that was very dear to him and has contributed so much knowledge. So I remember when we met in Perugia in Argentina for scientific conferences with colleagues, and even today we are meeting, in closer cities, even when we talk in university classrooms. Michele, however, was like a rock star. Sometimes people would hire an entire building for him to give a lecture. He had so many followers in Latin America, mostly, young people most of all, and they all wanted to hear him live. I'm the last one to speak as part of this panel. So probably most important things about factual errors have already been mentioned by the excellent speakers that have spoken before me. So I will do my best to find a niche and to combine knowledge about the two experiences that I was asked to share. First, as a professor of criminal law, specializing in evidence and evidential reasoning. I'm a scholar that is indebted to the work of Michele Tarufo from the civil law point of view in Italy. He was a referential figure because of his book on evidence. And the second experience is not only as a theoretical scholar, but also as a practical expert, as a practitioner, who for years now has used the American experience as part of this project in Europe and in Italy, a project that I've been leading for 10 years now, and with the Innocence Project Network, the European Innocence Network, which I chair. After these many years, I can say something that is not very original, but I hold this to heart. Preventing important errors, the horrible, sometimes judicial errors that take place, this can only be approached through a multifactorial perspective. There's no magic wand that can help you solve such a serious problem, but at least the solution whole mosaic of elements. The first one is the exact and accurate knowledge of the fact, as it has been said by my previous fellow speakers. In many countries, such as Italy, but not only, especially in Latin America, it's a psychological burden when they deal with statistics and empirical analysis on the criminal law system, which are fundamental, however, in this area. They are essential because they allow us to understand what went wrong in a particular case and to remedy that in the future, which is why what I'm trying to do in Italy is something that, well, our colleagues are great at doing in the US with the registry of exoneration, a list of people who have been exonerated and released because of a miscarriage of justice or an error that they were victims of. As Professor Gross told us, we all are indebted to him for this initiative. A registry of this kind allows us to understand what part of the machinery is blocked, what was the cause for that judicial error. And it's an extremely useful tool for scholars of this particular phenomenon, and it helps us learn from the past and to implement countermeasures conducive to avoiding this kind of errors in the future, both from a regulatory point of view and also in terms of best practices. The more general statistics are also important. An example, I was a member of the ministerial committee last year for the reform of Italian criminal process, and right away we understood that statistical data are scarce. They're not very elaborate, so much so that the current Minister for Justice said that we had to act on that field, and they set up a data control body, which is an essential step to do that. The second element, not only the compilation of empirical data and statistics, is to work on what we know are the most important causes for legal errors, and they are not conditioned by the traditional problem of comparing different procedural systems. We have also seen in the past few years that legal errors have common causes all across the globe, whether we're speaking about an adversarial system or a mixed system with its own unique features. So much so that it is possible to study this topic without making any distinction about the whole structure, the scaffolding of the system itself. And I believe that legal errors are becoming a driving force for us to come together, to come closer to procedural models of other countries. Let us think about the current flourishing of scientific research in the United States on the factual innocence. This is a system that has never included the pursuit of the truth as a cornerstone of the model. And still, today, they're suggesting that material truth is an important element after the trial, and that's part at the core of the discussion. It has repercussions on several stages during the proceedings, and it goes against the classical model, let's say. So the adversarial model could be changed and become closer to European paradigms. And we could speak about other elements as well. This shows how universal this problem is. Recently, there's been a hearing at the United Nations in which, well, there will be a hearing, and we will be participating as well. We will speak about legal errors and how to prove them. There's this first hearing with Brandon Hager from Duke University, Margot, Justin Brooks, and Barry Sheikh, who's a co-founder of the Innocence Project. Now, let me go back to the most common factors that may result in judicial error. The colleagues that have spoken before me about this particular point, well, the macro issues are obviously an erroneous identification by an eyewitness or by the victim, the science, which sometimes, instead of being a fundamental piece of help to determine the fact or a tool to destroy a judicial error, such as a DNA test, may be used and wielded and therefore be instrumental to the creation of the mistake. As Giulia spoke of false convictions, well, there's a current debate these days about questioning techniques, interrogation. The so-called chiamate in correltà in the United States, these are the so-called informers or snitchers. In Italy, I remember, I will remind you that only those that regret this, I mean, Giovanni Falcone's anniversary, the anniversary of his death is today, and I'm sure if you remember that time, the members of the mafia that renounced their belonging. And we could speak about soccer as well. There are a lot of metaphors to begin from there. But anyway, there might be a misconduct or a criminal mistake by the investigative forces, such as the police force. Be that as it may, after studying all of these famous cases that are well known, we can begin to think about the attention that a judge should pay on these issues. I mean, they're more prepared, right? And they shouldn't make the same mistake. But at the same time, we should think about possible legal reforms to change this, to avoid it. Let me just give you an example about interrogations. In the ministerial committee of which I was a member, I suggested a very simple correction, but that was quite difficult to take and to digest in many systems, such as the Italian system, which was to film, to shoot in a video all the questioning event, all the interrogations that happened. Right now, we're working on the implementation decrees, and I'm sure that in Italy, this cultural tradition that is so important might be accepted by legal operators. And the third point that I would like to make is as follows. The public opinion and raising awareness. I come from a country, Italy, in which the former Minister of Justice, during a TV broadcast that was 2 years ago, made this verbatim declaration. In our country, Italy, the innocent never end up in jail. So he obviously dismissed years of research, empirical data, so it becomes obvious that this awareness or information given to the public opinion, especially when it comes from the ministerial and judicial power, is very important. We're not saying we should attack the judicial system. Working on judicial errors doesn't mean clashing with it, but understanding that, error is human. So much so that in the United States, the strength of this innocence movement stems from the fact that, just like we do in Italy, they participate in a lot of research projects, and especially about specific cases, and the judges also participate, especially prosecutors. Let us remember that for some years now, in America, there have been, in a very efficient manner, the conviction internal units. These are departments or divisions in many prosecutors' offices, and these units have as their remit to prevent, identify, and remedy unfair convictions. Sometimes they are called conviction review units. Now, many of such units have reached extraordinary results in terms of the number of convictions to acquit in just a few years. And the great hope of academics and our American colleagues is that thanks to the work of such internal units that usually respond to the prosecutor's office, I mean, they work with lawyers and professors, but they are within the prosecutor's office, hopefully there will be a higher degree of interest by prosecutors day to day in order to mitigate the creation of such judicial errors from its roots. And fourthly, something also to my mind very important, has to do with training. Even during university, a great hobby horse of mine, which I share with many colleagues, Michele Tarufo used to say, it is not acceptable for a judge to have a lower level of knowledge about the cognitive tools than in other fields of human knowledge. It is obvious that this is extremely important. For instance, in our universities in Italy in general, there's no study on probabilistics. And I think that's very urgent. During your first years as a law student, you should be taught about this, the foundations of probabilistic reasoning, the uncertain kind of reasoning, these uncertainty situations, and the decisions to be made at the dawn of probability, which is a very typical exercise in determining truth. Law professionals need to take this kind of adventure, these risks every day. And there's an important number of fallacies in general that revolve around that particular topic. So from that lens, we cannot but mention the Bayes theorem. Michele Tarufo had already studied this many times in the past. I am a great proponent of the theory of probabilistics and Bayes' theorem. The famous Boston Conference in 1986, if I remember correctly, offered us a mosaic of the many different options available to us, as well as the different perspectives that could be helpful to break down this issue. And I have to say that this world phenomenon has come to an end in a way. However, recently we have seen many people reinterpreting Bayes' theorem but applied to evidence, and significant reflections on the visual representation, or in layman's terms, of these probabilistic elements of evidential reasoning. And as you all know, Edvard Vigmo and some of the great thinkers spoke about this. There are many people who are illiterate about this topic and the logic of probability, which means we should improve the legal administration's knowledge about transparency and the mechanic that underlies this evidential reasoning. In any case, we all agree that in order for a court to determine what's beyond any reasonable doubt, we don't need an expert in logic or an expert in statistics, but a judge that is kept abreast about the change in times. And obviously, this hasn't been yet done. There's no formula. There are no logarithms that can bring about pure justice. However, we can use modeling tools. We can see some logical canons that could come in handy. We could also understand these explicit explanations of probabilistic reasoning, which we all use in our day-to-day, but they're not intuitive in nature. They should be taught, and they may result in many errors. The most recent analysis on trial bias probabilities, I don't think they are dehumanizing justice. They are helping judges get better prepared and prevent more judicial errors. They are a contribution to the transparency of adjudication. Now, obviously, the deeper we go into this study field, the more easily we understand our vulnerabilities and the complexities of our reasoning. But obviously, we should not just hide the limitations of human being, which are the limits of a judicial assessment itself. If we hide that, we will not make any progress. Now, one last point, and then I'll draw some conclusions. Technologies. Now, when we speak about preventing factual mistakes, well, we cannot forget about artificial intelligence. However, AI, which is so important in the courts, trying to look for a correct justice rather than a fair justice. Obviously, I cannot deny that there's something very specific linked to the risk that AI may constitute a possible cause of error. There's also a consideration of an uncritical acceptance, let's say, of the products of such AI tools. However, I believe that somehow using these tools could bolster us and could reinforce the reasoning of judges and jurists in general. Instead of having the machine learning from people, in this case, people could somehow, by having a software that uses neural networks of a Bayesian base are able to infer correctly and they can learn, judges can, to think better. Well, at least that's what I hope. And I think it's an important frontier, an important issue to mention that can be read about in some of the works by Miriam Damasca. I'm talking about the introduction of AI, which might be dangerous for some specific determinations of fact, but understood as a collaboration vis-a-vis other types of evidence that from the time of Bacon and Beccaria thought that were exact, however, based on this new authority. Now we understand that they can also be used as part of a decision in and by themselves, as long as we don't have any other elements to judge from. However, when we have technical, scientific tools, or even AI applications that could be technically considered reliable, but that we can use as a support to understand our evidence, well, they can be used together with other elements by the judge when adjudicating. Now, in this case, we would be witnessing not the use of AI as an evidence for specific guilty nature, which cannot be accepted, at least for me, but rather as one other support, evidential support, which we already use, sometimes by its own, weak as it may be. It is not possible that the danger of miscarriages of justice calls on the reliance of shaky evidence.
This question has never been really treated by researchers of the criminal procedure, and sometimes it's the time to think that this evidence can limit the negative sense. And we can talk about progression in evidence, and in this case about scientific progression. I'm going to conclude. I think I have tackled 4 items here. And which is the most important one? Well, they are all important, of course, but there is the lumbrigus inter pares, which is one of the main causes, and we have already used this as a ground. Speakers just before me have already talked about the typical causes for judicial miscarriage. Michele Taruffo, when he's talking about judicial precedent, he said that this is like an island in the middle of a river. So there is some water, and that is why everything is free. But there are some islands that you can grab to, and there are some islands which are more reliable than others. And this is like the mapping that I proposed at the beginning. Probably each trial, each judicial proceeding is different. This important work that is being done all throughout the world is probably similar to these islands. You have the judge, the prosecutor, the defense, you have all the actors who want to grab one of these islands in order not to repeat these errors. Thank you so much.
Muchas gracias.
Thank you very much, Professor Luca Lubaria.
Vale la pena entonces resaltar estas
I think it's interesting to grab and highlight some of the ideas that you have presented here. One idea was presented at the beginning of your speech. How do we share these sources of error amongst different systems? Sometimes there are macro causes, macro grounds of errors, and it's interesting to analyze what other judiciary systems have done, such have done, such as the Italian one or the American one. And this way we can work on the errors and miscarriages. But I think it was very interesting as well to listen to this suggestion about police forces. For instance, when you were talking about recording in video the statements, because this can be easily applied and used. It's not that commonly used. There are different elements in our system that prevent us from using it continuously. So thank you to all of you, the four of you, because all your speeches were really relevant. We are going to open the floor to questions. As you know, you can use the app. The speakers can also take the floor orally here. They can ask for the floor also using the app. So if everything's ready, we can start, and we'll give the floor to Yanaida Matilda. This professor, she has asked for the floor. Please, go ahead.
Hola. Buenas tardes.
Good afternoon. Thank you very much for the organization of the event. Everything is so nice. And we are so happy to be here in person. I would like to ask a question to Giulia. I really enjoyed her speech about the fake confessions. And there is something you mentioned about how these declarations are done, these statements are taken, and how the way these statements are done, this has an impact in the result. Maybe at the end of the day it's going to be false, because we are directing or guiding somehow the questions, because we don't have the enough technical capacity to guide them. So I thought it was also very interesting to listen to what you said about police forces. It's not enough to train those who are at the trial, the prosecutors or the judges. This is not enough, because everything starts before. The beginning is where the police forces are. So if we also have to think about the investigative phase, because here we are going to have as a consequence a poorer or a richer questioning, maybe our challenge here is not just technical, as we are mentioning right now, because here we are in this evidence congress in order to talk about the technical quality of proof, etc. In Brazil and also in Chile, we are making lots of efforts to try to change regulations, to improve them, to have different protocols and different evidence measures. And maybe this challenge is a shared challenge here for all of us who are here today. We need to raise awareness to these authors, to the actors, to all people who work in the police forces. We have to raise awareness towards them so that they understand that there is technical on one hand, but at the same time there is a virtuous and ethic commitment of the police forces. And this is something that maybe we should treat at epistemological level. In Brazil, when we are talking about training, it's really important to train about racial issues, for instance. So I would like to know what you think about that, this relation between technical knowledge and epistemology, of course, and the need to train also at technical level, virtuous training. I think we should try to link this to epistemic unfair situations that we are continuously making in criminal justice. Thank you so much.
Thank you very much for the question. Apologies that I'm answering in English. But yes, I totally agree with you. It is, I think, crucial to have this integrated approach. And what is relevant now is to have it on a structural basis. That's something we are lacking in Italy for sure, but not just in Italy, as I understand it. and also to build this path in a way that is clear also to law enforcement, that following certain kind of rules and not others, practical rules, it's not a way to diminish the efficiency of their investigations, it's a way actually to improve it, because sometimes this idea that you need to find a culprit, sometimes there is also pressure from the media and pressure from the hierarchical organization, and I think there is an underestimation of the extent to which making these mistakes in these very first stages of the proceeding not only risks to convict the wrong person, but also, or to incriminate the wrong person, but also to disregard the real hints that brings to identify the real culprit. And therefore it is very much in the interest of also law enforcement perspective of their job to ensure that the victims get justice, but the method matters. And that I think it is the added value that we can give, that we can try to give. And absolutely I agree, it has to be done through a multidisciplinary perspective. It has to be done not sporadically. It is high time we stop to leave the training of police and law enforcement to simply getting information from the older colleagues or exchange practices. There is a lot of studies, and this is, I think, a problem also on how, again, university studies are structured at the moment. There is not enough interest into incorporating these models already in the studies. And what happens, therefore, is that sometimes, at best, you have law enforcement that publishes its own guidelines, which, of course, do not include also this perspective that it's maybe more difficult to capture if you didn't have all this background information and studies before. So I think here there is a challenge for us as academics to go out of the academic world and really interact with people that do this job in practice and try to present that not a way just to reduce errors, but also to make justice, whatever we mean by this big word, or seek for the truth, better, at least under procedural perspective, in a way of fairness. I think that's very important and relevant, and this is something that can be done, and therefore it's really unacceptable, I would say, to today to leave it to just be carried out by itself. It's something we can intervene upon. There's some types of mistakes related to, I know, AI applications we do not know how to solve yet. This we know, at least to a certain extent, and I would say it is our task to make sure it gets applied as best we can. Thank you.
Thank you very much. Is Professor Gross in Zoom? I have a question for you, if you are still there.
I am here. Oops. Yes, I'm available.
Okay, I can see you, but I can't hear you. Well, Professor, here is a question from the public. Regarding the high rate of 56% of official misconduct that produce false evidence, what is the rate of those officials who committed a misconduct that were prosecuted and sentenced for creating false evidence?
Can you hear me now? Can you hear me now?
Hear you.
The answer is it's very low. There are two categories, police officers and prosecutors. Among police officers, a small minority, perhaps 5% or 10%, are disciplined at all, receive any sort of discipline, and only a much smaller group, perhaps 1 or 2%, have been criminally prosecuted and convicted. Among prosecutors, almost none receive any sort of discipline. Of all the prosecutors that we know about who committed misconduct in cases that later ended up as exonerations, 2 were convicted of criminal offenses. 1 spent 3 days in jail. The other did not spend any time in jail. The one who spent 3 days in extreme misconduct, deliberate misconduct, that resulted in a man going to prison for 25 years for a murder that he did not commit. Those are the only two cases of any prosecutor who's been convicted of misconduct in a case that we know about that resulted in exoneration, and almost none of them are disciplined at all.
Okay. Thank you very much. Ahora el uso de la voz lo tiene el profesor.
Now I'm going to give the floor to Professor Mauricio Duchel. Please, go ahead.
Hablando sobre errores.
We are talking about misconduct. And we can see an error here right now.
Aquí va otro. ¿Es el micrófono o es Mauricio Duce?
Is it a problem related to the microphone or to Mauricio Duce?
El tercero es el vencido.
Let's try again.
Hola. ¿Ahora sí? Hola, ahora sí. Bueno, muy buenas tardes. Muchas gracias a los
Thank you so much. Good afternoon to everyone. I have here an open question for anyone who wishes to answer. I'm not sure if the four are with us right now. First of all, I'd like to clarify something. I agree because I think you all emphasized measures to prevent and to improve the system and to have a better space, and that at the end of the day probably we'll have a system which can prevent both false positive and negative cases, and we have to focus on that. But I would like to talk about something else which wasn't that mentioned here, probably because you were focusing on something else. And I think it's a challenge that we have right now, and it appears here at corporate level. What I have seen is that in different countries, including Italy and the United States, proves that once the errors have been committed, criminal justice systems do not have that much capacity to correct, to put some remedies to the errors. This capacity is really low. And in Chile, I can say the situation is similar. Problems are shared. I can say that sometimes we cannot access to reviewing convictions because it's so complicated to get to this situation. There is no, it's so expensive. They need some technical support which sometimes do not exist. There is a problem with the scope, with causes, maybe because standards are too high, or maybe because they are too restricted, many reasons. So at the end of the day, the possibility of really reviewing something is not happening. And there are some innovative examples. The review commission of some cases, this is something which happened in England, and this is a good progress. But then there are many criticisms saying what, example, what Luca was just saying, the conviction review, the units and that kind of things. But as far as I know, this is something just happening in the United States. So I think we have a problem. So how do we take care of the errors once we weren't able to prevent them? We do not have a real solution here in comparative law, and we do not have enough information. So except factors that have led to these errors, that's all we know. So I would like to ask you, we are here talking about correcting convictions. How could we start working? Which are the key elements to create an agenda in order to take care more seriously about these existing problems? Maybe you can highlight one or two elements here according to your experience in your respective countries. Thank you so much. So if Professor Lubaria is here, maybe he can take the floor. Apparently he's not there. Mr. Epps, go ahead.
If that's okay.
Okay, first Professor Epps, and then if you want, you could take the microphone.
Okay.
Professor Epps, microphone.
Hello. Okay, there it is. I'll just say something quickly, which is that rather than give a solution, say that this is a very hard problem and one that we deal with in the American legal system because there is a very strong desire among various actors and among judges for the value of finality, that we want the trial, there's a Supreme Court opinion that says the trial should be the main event, and there shouldn't be endless rounds of review over and over. We should try to have all those things resolved in the trial. And that said, there have to be some avenues to question trials, the results of trials, not just a few years down the road, but many years down the road on the basis of newly discovered evidence. And, different jurisdictions are more or less willing to create space for those challenges, I think in part because they are afraid that we're just opening the floodgates and every defendant is going to start making these claims. I think those fears are overstated. But one very troubling thing we see is that even in cases where there is clear evidence of exoneration, sometimes the prosecutors will continue insisting that the defendant must be guilty and will not take steps that would be necessary to sort of move towards exoneration. So I think a challenge there in resolving the right set of procedural questions is one that can enable these avenues, which really need to exist, without raising the concerns of the people who are very focused on finality and the cost of litigation, that this is going to open the floodgates to a bunch of other claims.
Thank you. Thank you very much. Professor Gross?
Actually, Professor Epps said most of what I was intending to say. I'll just reinforce it slightly. There are concerns, and perhaps legitimate concerns, against reopening cases and reinvestigating them. And we see that in the United States and the exonerations we know about all the time. It's hard to figure out how best to use limited resources to reinvestigate cases. But there is one relatively easy change that could be implemented in cases that come up reasonably regularly in the United States and probably in other countries. And that is to be more open to reconsideration of cases where the defendant has presented substantial evidence of innocence that was not presented at the original trial. There are some cases in which that happens, and some prosecutors and judges who say, we're happy to look at this again and review it. But there are hundreds, if not thousands, of cases in which defendants were ultimately exonerated in the United States, in which the initial response is, we don't want to hear from you, and we don't want to look at the evidence you now have that wasn't presented earlier. And that would be a relatively easy thing to change.
Profesor, no sé si quiere añadir algo más.
¿Me está escuchando? Quiero hablar sobre la pregunta del profesor Dulce.
I wanted to answer to question to Professor Doce. In my speech, I was talking about the hearings at the United Nations last week. For me, this is something very important because we need to establish a fundamental right to the review of the conviction. This will allow to diminish the differences among countries in Europe and outside Europe, because there are some states where there are just 1 or 2 reviews per year. This is lucky. There are too many filters, there are too many strict criteria, there are no laws which allow to have the proof for so many years, the evidence for so many years. The chain of custody does not take many years, so then time has already passed. There are some countries where there are some laws where we can consider something as a new evidence or a new analysis, scientific research of the same object which was used as an evidence in the other stage before. So, we should harmonize things. This should be a fundamental right in every country. There should be a right of the review of the conviction, of this revision, and this could help us. Of course, it's impossible to have a filter here and some screening before we reopen, but we need to have something established and harmonized.
Gracias.
Thank you.
Professor Lubaria,
there's another question in the public for you. In Italy, which is the procedural tool and the prerequisite of its source in order to allow the reopening of a final judgment. In Argentina, we have the revision appeal, but in order to be able to do that, we need something new, something which wasn't already valued by the court before. And this makes reopening cases quite hard. And sometimes the problem of the conviction is really linked to the assessment of the evidence. Yes, in Italy, we also have an appeal for review or revision. It's similar to Argentina, and it's also based on the new evidence. But luckily, the Supreme Court has said that this new evidence can be this new analysis over an old evidence. So this is the big difference with other countries. We have different cases of review per year. This is something good. But there are just a few if we compare them to the real number of questions of justice in our country. I mean, it's something linked to our mindset or our culture, linked to how judges see this revision or this reopening. And we also have another issue, which is that criminal proceedings do take 10 years, so this is horrible. So mentally and culturally speaking, judges, they don't want to know anything about reopening them because they have already been working 10 years in that case, so they just don't want to listen to anything else about that specific case. And it's not linked to technical things, it's just something linked to mindset. We have many cultural reluctancy for these kind of things. We are not just using law and criminal procedural articles. Sometimes it's simpler than that. Thank you so much. So now José Luis Ramírez Ortiz has the floor. Here on the left, please.
Buenas tardes. Igualmente agradecer las intervenciones de los ponentes.
Good afternoon. Thank you very much. Thanks to all the speakers because they have had fantastic presentations. I'm quite worried about something here. We are now seeing this populism and these times where everything tries to be solved from the same perspective. I'm kind of worried because if we take philosophy of law and dogmatic law and ideas and approach, maybe we can finish by ending, but there is a link between false conviction and false solution, at least from an epistemology point of view. And I think this is different. False conviction is one thing and false acquittal, is something else. There's just one legitimate case, and this is the only, there's just one approach for citizens to be convicted, and we cannot compare both things. Acquittal and the solutions and these problems are not the same. So maybe if we are using this discourse, we can give a wrong impression, and the rule of evidence exclusion or the different exonerations or waivers can be seen as something linked to anti-epistemology, and that's not the case because there are epistemologic elements, and we are just trying to achieve some quality here. So the only way to get quality is to comply with law. And there was also another interesting question when we were talking about misconduct at police level and how can this deal non-unfair conclusions. I would like to show something that happens here with the Latin culture. The police forces and the law enforcement forces, they do not want to do things because of negligence or bad faith, but the way they understand all the police proceedings and how they understand the statements and the witnesses, at the end of the day, all these provoke bias, and this has an impact in the process, because some of the declarations are choral declarations, because police forces are just getting some statements in a collective way, something choral altogether, and then we know that this is not the well approach, because the declarations and the statements of some witnesses do have an impact and interfere in the statements of others, but police forces, when they go to trial and they act as witness, they talk in plural, and they are saying something as if it was individual, but they are talking in plural because they have already talked to their colleagues. And I think we need to change this because it needs to be tackled from a procedural point of view. Thank you, José Luis. Professor Epps, would you like to...
About the first question?
I had a little trouble keeping up with the translation.
You have troubles to understand. Professor Gross, I don't know if you want to say anything about the first question or the second.
No se entendeva muy bien, Y no sabe si el profesor Gross ha entendido algo.
I'm not sure if Professor Epps has understood interpreters. I apologize, but there are two microphones open at the same time, and we are trying to solve that as we cannot listen to the speech properly.
Thank you very much for your observation. And I don't know if that can be of any use, but I think for that the Italian legal framework was interesting because we had these same problems to a certain extent, and when there was the change from the inquisitorial system to the adversarial system, that was one of the key issues on which there had been much case law after the reform. First, police was banned from testifying about statements that police received during investigations of the defendant or of other people. And then there was a lot of changes also in the case law showing the difficulty of the judiciary to adjust to this new rule, and that there was constitutional court intervening, so there was a lot of back and forth in that regard. And the current status went back to a certain extent to this more adversarial model, and in that sense maybe that could be a useful model as well, in the sense that currently the system by law in the criminal procedure code does not allow law enforcement to refer on statements. They can testify about what they did on searches, for instance, or on other types of investigative measures, but they cannot tell to the judge what other people, defendants or other kind of people, refer to them. So at least for that, there is a need to hear the direct sources directly, let's say, and therefore to this, to a certain extent at least, reduce that it is just the narrative of the law enforcement that is influencing how the judge is perceiving the reconstruction effects. And I think this is a key issue that you can see quite much also during court cases, really practically. And it's quite often that police starts to say, this person told me that, and the judge or the defense lawyer have to intervene and say, no, you can't say that, because still after 30 years of the change of this law, still culturally there is difficult to adjust sometimes. But I agree with you that that should be done at a more systematic level. It needs a regulation of some sort. It cannot just be left to practice, because otherwise there is very much this flattening over just one version of the events and not really adversarial or bipartisan reconstruction of events. I hope I addressed your comment.
Thank you. There's a question for Professor Epps from the public. Would you agree that even if the standard of proof does not distribute errors, it distributes the risk of error between the parties? Conceptually, the higher the standard of proof, the higher the risk for the prosecutor to lose the case. and the acquittal verdict would be more likely to be factually inaccurate?
I think so, with the caveat that, exactly, if the question is, we don't know what distribution it creates, but I think it certainly has to be clear that as you make the burden more demanding, it changes things, right? If the burden were absolute certainty, no one would ever get convicted, because there never is absolute certainty. Whereas if the burden is, preponderance of the evidence or, probable cause, one of these lower standards of evidence, many more people would get convicted. So clearly it has an effect along that dimension. My claim is just that it doesn't necessarily tell us. We can't go from some preference about how we want errors to be distributed and then necessarily understand, through mathematically what the standard of proof should be.
Thank you very much. There's another question for Professor Gross. Professor Gross, due to the centrality of plea bargains in the criminal justice system, what is the impact of racial profiling stemming from stereotypes and biases in the process of plea bargain offering and in shaping plea bargain outcome?
So that's a very important question.
Pues es una pregunta.
First, it raises an issue that I wanted to address as a comment on Professor Epps' excellent presentation. Professor Epps talks about trials and about the distribution of results of trials, false convictions and false acquittals. In fact, however, there are not many trials in the United States. Among the cases that we see mostly in the National Registry of Exonerations, which are felonies, about 95% of the defendants plead guilty, almost always as part of a process known as plea bargaining, under which they receive a lesser sentence or are allowed to plead to a lesser charge in order to plead guilty and save the trouble of having a trial in which evidence is presented. On the other side, there are not very many acquittals at all. There are very, very few acquittals. Of the cases that go to trial in the United States, criminal cases, which is a very small minority, the great majority result in convictions. However, many cases in which defendants are initially arrested and charged do not result in convictions. They result in dismissals before trial. The overwhelming number of cases in which defendants are arrested and charged in the United States result either in guilty pleas without trial or dismissals without trial. That's where how the system in fact operates. And in that process, the process of determining guilt or innocence by plea bargaining, all sorts of things take place that are almost entirely invisible. The record keeping in those cases can be non-existent. In many cases in which defendants plead guilty and go on to serve perhaps 3 or 5 or more years in prison, the only official record of the case in court is a record of a short hearing in which the attorneys and the judge may speak for 5 or 10 minutes. The defendant pleads guilty, various formal statements are made, and a sentence is pronounced. Behind that, in some cases, the only record of the evidentiary basis of this proceeding may be a police report that could be anywhere from a few sentences to a few pages that may be impossible to locate. It will not be part of the court records and will be very hard to obtain in many states from any other source. The reason I'm saying this is because the type of data that I was talking about does not generally exist for this. But when you talk about patterns of criminal convictions in the United States in general, you are overwhelmingly talking about the product of these proceedings that lead to defendants pleading guilty on one side and other defendants having the charges against them dismissed on the other. And there is every reason to believe, judging from the outcomes, the number of people who were arrested and convicted, and the proportion of people who end up in prison, that racial biases play a role in that process. They play a role in that process for many reasons, partly because of the biases of the participants, and partly because plea bargaining is an event that is supposedly, and to some extent, in fact, based on the predictions the prosecutor, the defense attorney, and the judge make about what would happen in the extremely unusual case that the actual case goes to trial, in which case they anticipate the possibility of discrimination on the part of the jury or the judge. Beyond saying all that, I cannot say there's specific data on this. There is a great deal of data on discrimination in some contexts on the part of police officers, especially in tasks that are repetitive and routine, traffic stops, searching defendants and their vehicles after they've been stopped, and prosecuting low-level crimes, especially drug cases, where there is strong evidence of racial discrimination that can be determined from what we're able to obtain from the police.
Muchas gracias.
Thank you very much. We now give the floor to Professor Jordi Ferrer, who is here right at the front row.
Muchas gracias.
Thank you. What I would like to say goes for any of the four speakers. I would like to congratulate them all for their presentation, and it's in keeping with some of the comments by Mauricio Ducci. I believe that when one thinks of rectifying mistakes, making good on errors in our countries, we're thinking mostly about proceedings. If we talk about a criminal procedure, in what we call revision of a conviction that has been pronounced. However, I think it's a much greater problem, because that's the problem when we start going over a judgment that had been already passed. If we get that far, because it's very difficult, the damage that has been done, that has been inflicted on the innocent person, is already great. They have already stayed for years in prison at the very least. How come are our systems unable to have this kind of corrective measures before we get to that extreme? And I'm thinking about how to appeal mostly. I believe that we are facing two important problems from that point of view. The first of them has to do with decisions that were taken in a first instance court after the first trial, and the second has to do with decisions made after a plea bargain agreement, this kind of shortened trial, or whatever term you want to use depending on your country. I'll start with the latter. There's no effective control mechanism by the trier of fact vis-a-vis the agreements that the lawyer and the prosecutor may reach as part of a plea bargain. There's no mechanism, there's no standard of proof, there's no demand for control by the trier of the case in order to control whether that agreement that the defendant and the accused may have reached, and whether it's a way of recognizing a true culpability, or if the agreement is based on other, even rational considerations for the accused, but they don't mean that he or she is guilty. If somebody is in a pre-trial detention and they're offered a judgment that would mean that they would be free the next day, well, even if they are innocent, they may plead guilty as long as they are out in the street right away. And that leads to false convictions all the time. There are so many false convictions that will never be revised, and they will never be controlled under the Innocence Project supervision, because we have created this great vehicle, let's say, to ensure guarantees during trial, but a lot of cases are fleeing our way, they're escaping from us through a plea bargain second mechanism. Secondly, how can we correct the first instance court decision as an appeal procedure? And the greatest enemy here is immediacy, because if we don't fully understand this immediacy, we are limiting the control that can be exerted by the Court of Appeal. And in the Spanish case, they do not really understand the standard of proof. I have to say the Supreme Court or the Constitutional Court. They're so ill-acquainted with it that they say as follows: standard of proof for a criminal conviction is beyond a reasonable doubt. However, what should be controlled in the Court of Appeal is not whether there was evidence beyond any reasonable doubt, but rather whether the conviction, whether this hypothesis of culpability that was declared proven is more likely than the opposite, which means that we have transformed this prevailing probability into the only standard that we can control. We're telling the first instance judge that with this prevailing probability, he or she can already rule, because that's the only thing that will be controlled in the second instance, which means that the standard of proof for the criminal procedure has been lowered down. It's a problem of control because we want to limit the number of cases in which that will be controlled in a second instance court. The decision made in a first instance court, invoking that holy, sacrosanct way of understanding immediacy. It's not a question, just a comment, and a suggestion for any of the speakers to go deeper into it. Thank you very much for participating.
Professor Epps?
Professor Epps. There's a lot of really interesting things to talk about, and I think the point that both you and Professor Gross talked about is how plea bargains or guilty pleas are interacting with this. And in our system, it makes things even worse because you can often be punished for pleading guilty, but then sort of insisting on innocence. You won't get a sentence reduction for acceptance of responsibility. So you get a higher sentence if you plead guilty but say, no, I'm really innocent. In some states, you cannot be released early on parole unless you admit you committed the crime. And so if you're still saying, yes, I was convicted, but I deserve parole, I've been a good prisoner, they'll say, no parole, you didn't accept responsibility, you don't show remorse, you're denying that you commit the crime. In terms of preventing those things on, you might say, the front end, one thing that we struggle with in the United States is federalism, in the sense that the courts that are more willing to protect defendants against the worst kinds of miscarriages are not the same court system where those miscarriages are happening. So federal courts have been much more receptive. I mean, I don't say they're very, very receptive, but they've been more receptive to claims trying to address miscarriages than state courts, which often have very loose procedures and really run roughshod over the rights of criminal defendants. And so the federal courts are often coming in, not just on appeal, but many steps down the line. There's been appeal, it's gone up, it's gone through the state post-conviction process, and then eventually it gets to federal court. And it's very, very late in the day, and someone might have been in prison for years at that time. And often it's too late for the federal court to do anything about it because they've given up all their chances to make these arguments. And so I think figuring out a way to focus on prevention rather than just redress after the fact is critically important.
Gracias. Thank you very much. Is Gross or Professor Lubaria, you want to say anything about the question or the comment?
I could say something about that.
Okay, great. Go ahead.
So, I'd like to talk about one of the issues that was brought up, and that's time. Hold on one second. And that's time. The average time from conviction to exoneration in the cases that we know of in the National Registry is about 10 years. The longest times are 30 and 40 and 50 years. The average amount of the number of years that the exonerated defendant spent in court is over 9 years. What this tells you is that the process of exoneration in the United States, which has become much more active than it used to be, basically helps a small minority of defendants who were convicted and sentenced to serious crimes and received very serious penalties. And then below that, there is a scattering, a small scattering of some number of very arbitrary cases in which defendants received lesser penalties or were convicted of minor crimes. In many cases, defendants who were wrongfully convicted and served a year or two in jail and then left, or received a year or two probation, are not exonerated in the face of evidence that becomes available to them just because nobody knows where to find them, or they've lost interest in the case, or they don't want to have anything to do with it. They don't want their friends and associates to hear that they were convicted of a crime 20 years ago, but oh, guess what? I was later exonerated. They just assume it was in the past. So the process that we're talking about is, with few exceptions, only available to people who have extreme long sentences. And those are overwhelmingly people who went to trial. As I said, that the great majority of defendants in the United States who go to prison plead guilty, 95% or so. Only about 20% of the exonerations we know about are from defendants who pled guilty in a system in which that is almost all of the people who end up in prison. And that's partly because they get lesser sentences, and partly because they waive rights to appeal, and partly because people are less likely to believe they're innocent. One more thing about federal courts. Some federal courts have been extraordinarily useful in creating legal precedents for exonerations and taking up very difficult cases. But federal courts almost never get involved in these cases. The exonerations that we know about are mostly done at the state level. Often the main actor, perhaps as often as not, the main actor is not a court at all, but a prosecutor who has the authority to dismiss a case even years after the conviction. And on this issue and on every other, the difference from one location in the United States is huge. There are, as you know, 50 states in the United States. But the real unit of analysis for the criminal justice system, the geographical unit of analysis for the criminal justice system in the United States, is not the 50 states. It's the 3,000 counties, each of which, with few exceptions, has a separate court system, mostly with judges who are elected by the local population. Most of these counties have separate prosecutors who are elected by the local population. And the differences from one county to another within the same state, 2 or 3 kilometers apart, can be huge. And some of the judges in state courts are far more useful and helpful in dealing with false convictions than federal judges who get many fewer cases. But for the most part, the issue is, in fact, dealt with primarily by prosecutors and defense attorneys, as is the entire process of adjudication in the United States in criminal cases.
One remark is possible.
Sí, profesor Lubaria.
Sí, sobre las últimas preguntas.
Just to respond about the last questions. In my opinion, in the criminal paradigm, miscarriage of justice is only a false conviction. Otherwise, we could call into question some fundamental principles of justice. Obviously, the accuracy of the determination of the fact in general during a trial is extremely important, but in my opinion, an error of justice, according to our paradigm, has only to do with false conviction. Now, can we learn about the plea bargain experience in the United States? We have already said that it's a very dangerous institution because of the errors that may be committed. However, in the the US, at the very least, there's a lot of interest in the willingness to negotiate as part of a plea bargain. I once witnessed, I think it was in Cincinnati, if I remember correctly, or maybe another city. There was a plea bargaining agreement with a lot of questions being asked by the judge. How do you know that if you plead guilty, this will happen, this other thing will happen? Why do you say this? Because in Italy, for instance, it is possible to negotiate the patteggiamento, which is the Italian version of plea bargain, without even going to a court or seeing a judge. The lawyer, him or herself, pleads their client guilty without any verification that that person is willing to do so. It's a small thing that we can learn, right, from the United States. That could be improved. And this is the beginning of the beyond any reasonable doubt. In Italy, if you appeal so that people go over your trial, we also say it has to be beyond all reasonable doubt. It's enough to just speak about a possible doubt. Then you need the best case law, obviously. But there is an important step, and it has changed in the past few years. In order for your conviction to be revised, it is enough if you raise a doubt, a reasonable doubt. Thank you. Thank you, Professor Lubaria.
There's the last question for Professor Gross. Is there a study of the causes of wrongful acquittals as systematic and insightful as there is in the case of wrongful convictions? Should we not have such a study if the goal is to reduce both types of mistakes?
So it's an excellent question, and the short answer is no. To add just a little bit to it, first, there's a question of what you mean by wrongful acquittal. Professor Epps, in an excellent article, makes the point that you can include in the concept of wrongful acquittal all of the cases in which a guilty defendant is not convicted, or just those in which the case goes to a trial and the trial court makes a mistake. And he says it's the second category that he thinks he should focus on, and I think he is correct, of course, because, well, not of course, but he is correct, because the meaning of failure to convict is so dramatically different from one type of case to another. For example, in the case of drug convictions, basic evidence, as best we know, is that on any given day, somewhere between 5 and 20% of the American adult population, that is to say, dozens or hundreds of millions of people, commit drug crimes by American legal standards. Almost none of them are convicted. Almost all of these are ignored. Maybe it's as low as only 2 or 3 million a day. That would be extraordinarily low. It could be 50 million a day. Lots of crimes, this is a category known as victimless crimes, are not prosecuted at all except in very rare cases. And that applies to many types of crimes, gambling, most traffic offenses, talking about minor ones, but it applies in the United States, for example, to many financial crimes. Tax crimes in the United States, and I suspect in Europe, are almost never prosecuted. Almost never. So on our far end, though, when you get to homicides, when someone has been killed, almost every case, and in theory, absolutely every case, should receive a serious investigation. And if there is a suspect, a suspect against whom there is substantial evidence, that suspect should be carefully investigated. and if the evidence warrants, arrested and charged and tried. And most police departments and prosecutors operate on that premise, and then to a lesser extent apply that to other very serious crimes of violence and so forth. And in some of those cases, especially for homicides, it might be possible to get useful information about the process that produces charges in some cases, but no charges or no arrests in other cases. In other cases in the United States, and I suspect elsewhere, that information doesn't exist and would be extremely hard to collect. Among the cases that do go farther along, among cases that go to trial, as I mentioned, very few result in acquittals. If people are not convicted, it's usually dismissed, and again, the information we have is extremely limited or non-existent. Among the cases in which there are acquittals, and now we're talking about a really very small minority, people have looked at least impressionistically to try to figure out why cases result in acquittals, and how many of those are defendants who might be guilty. But I cannot say that there's any systematic evidence on that that's worth discussing.
Thank you very much, Professor Samuel Gross. Muchas gracias a los cuatro.
I would like to thank the 4 panelists of this afternoon event on errors in judicial decisions. I kindly ask you a round of applause for the 4 of them. Just a couple of announcements, housekeeping notes for you. As you already know the place where we are and how to get to this convention center, tomorrow there will not be any meeting point organized for participants who walk all the way here jointly with members from the organization. Please don't make any mistakes on that front tomorrow. We shall begin tomorrow at 8:30 with the lecture by Professor Roland Allen with a title that encourages us to wake up early. Theory or science of the proof. Judicial epistemology knows its parents and is not happy about it. Thank you all so very much for your attention. To you all tomorrow. Enjoy the rest of your evening.